I can't. I have to show you that we mean business. Otherwise, we have no teeth. You know, what we say means nothing. And I'm going to tell you now that.
Excuse me, Your Honor, I'm approaching on Neil White. And Judge, he's been carried since Monday, the 24th. That's when he appeared on your docket initially for a new charge for the bond violation report, which is filed, and also a motion to revoke and raise. But he was still incarcerated on Monday, Judge, Monday morning.
He's right here now, right?
He's here now.
Okay.
But
Come up, Mr. White.
Mr. White.
We're on bond for an assault of a family member.
Yes, sir.
Since 2023.
Yes, sir.
In 2025, in February, you pick up a terroristic threat.
Yes, sir.
And now you've picked up another assault of a family member and a violation of a protective order. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes.
You have the right to have an attorney present. If you cannot afford one, will be appointed to you.
On May 16th, 2025, in Harris County, Texas, officer was dispatched to an apartment for a family assault. Officer met with the complainant witness. The complainant witness had visible injuries on her face, including bruising on her eye and swelling on her head. The complainant witness went over to the defendant's house. Defendant grabbed the complainant witness by the arms and threw her into a table and chairs. Defendant began to punch the complainant witness multiple times in the stomach and slap her in the face. Complainant witness attempted to leave, but the defendant followed her through the apartment complex. The defendant currently has a protective order for terrorist threat, which bars contact between the complainant and the defendant.
Is that the violation of protective order?
Yeah, it's a felony.
Your Honor, may I be heard? Your Honor, the complaining witness shows up at my client's apartment. He lives there by himself. She shows up like at 5 a.m. in the morning. My client did not assault her in any way. I actually, the complaining witness broke his phone, and my client left the apartment so he wouldn't have to deal with her because she wouldn't go away. But at no time, Your Honor, did he assault her. I did get to check out the videos, Your Honor, where the officers are interviewing the complaining witness. She alleges that he punched her in the abdomen. She is in absolutely no distress, Your Honor, when she's talking to the, if he had punched her in the abdomen, Your Honor, can say that she probably would be doubled over and would want to go to the hospital. The EMS did check her out, it appears, but she refused transport to the hospital. I couldn't tell from the body worn cam video, Judge. It wasn't close up enough, but I couldn't tell. I couldn't see any bruises and it's like I said, she was not in distress whatsoever. She is the one who really went to his apartment. He did not go, he did not violate the
Violation of protective order is a felony offense anyways, so.
Yes, Judge, I understand. I understand.
So I just have, an assault, a terroristic threat, and now another assault.
Right.
So which assault is he alleging that's the?
Right, Judge.
Right.
Yes, Judge. And the state has filed a terroristic threat on her behalf, charge on her behalf. If she was so terrified of him, Judge, why is she popping up at the
I don't know
apartment?
that that's actually true. Who's saying, he's just telling that to you? I mean, how do we know that's really true?
Well, she's there, Judge. Those are the apartments that are shown on the body worn cam video. It's his residence.
Is she actually on video at his apartment? Have you seen it?
Outside of the apartment, they're outside on FM 1960. That is not her residence. The protective order has got a totally different address where he is prohibited from
Tell me, Sebastian.
going.
Okay, well, the VPO is not based on an address restriction. It's based on the assault of a protected person. And as far as the representations that defense has made today, we have no way of verifying any of that to be true. I disagree with the assertion that she shows no visible injuries. Her face does appear to be swollen with some red markings. Or three, the allegation that she's over at the house don't disqualify her as being a protected individual, and VPO is for an assault, not for a residency restriction. And at the end of the day, all those are fact issues, and what we're left with right now is the fact that in 2023, with a separate victim, he has an AFM, bond forfeits, then we have a terroristic threat with someone else, and now he picks up a separate AFM. And we can talk about how she's back all the time, but I think that ignores, first of all, the realities of domestic violence situations. And second of all, this isn't just one person that she's having multiple problems with. These are two separate people. So the state is going to stand on its motion to revoke and raise bail and is going to ask for 20,000 on all three cases.
Your Honor, may I respond? The complaining witness has not recanted to these March 16th, to the current charges, to the newer charges.
Which alleged victim is recanting, the first or the second?
The terroristic threat complaining witness, Your Honor. And the other assault family member case, Judge, the complaining witness is currently incarcerated. But
So which one's the
so,
The oldest one is in jail.
and
Or
I'm not sure, actually. I had a colleague who spoke to her. I forget exactly which is in for. She is in jail. As far as her recanting, I mean, that's,
is she in jail for something against him?
no, I don't think so.
And also, Judge, the complaining witness, the one that the protective order is on behalf of, she has not given a rip on the terroristic threat case, Judge. So something's not right. She doesn't want to.
Problem is
Tell the truth.
stuff keeps happening to him. It's just, I mean, I fall and I pick up a new case.
Yes, Judge, and I did want.
Are we supposed to just let him go because he's picked up now a felony? You
I
know,
just wanted to relate to you, Your Honor. My client does not have funds. He paid to get out with his income tax return, Your Honor. He paid to get out on these two new charges. He paid to get his car because he was not arrested at the scene, but he was arrested thereafter while he was driving. They impounded his car. He paid to get his car out. And he paid because to get a new phone or get his phone repaired because complaining witness broke his phone on the date of the alleged incident. And asking the court to leave his bond as is, or in the alternative, Judge, maybe he can borrow some. He's got $250 left from the income tax return. And if you could leave it, or $5,000, he could do that, but not 20. He was in jail for an entire week, Your Honor, when he was arrested for this offenses.
pick up new cases. What happens? I have not asked you to do anything but be safe in my community. You're now working your fourth case. No, I don't want you to say anything. The only thing is that you continue to pick up new cases, and I can't just let you keep doing that without some kind of consequence. No, there has to be consequence to behavior, and the bill comes due. You can't continue to pick up new cases and expect good results. So I'm now going to revoke your bond. It goes with you. I can't. I have to show you that we mean business. Otherwise, we have no teeth. You know, what we say, it means nothing. I'm going to tell you now that I'm entering an order for protection in all these cases. And if you violate this, I can have a hearing to hold you at zero bond, and I will do it in a heartbeat to protect my city at all cost. If this person comes to you, you don't open the door. If they call you, you don't open the door. Or I'm sorry, you don't answer the phone. If they email you, you don't reply. But at some point, we have to say when. Now's that time. It goes with you. I'm not going to set it that high. I think that high is obtuse, and that's just, mean-spirited to go that high. But
Judge, this is 2 years worth of history here. Two different people.
that's why they set the felony bond at 30,000. But I mean,
You gave the first victim 10 stitches in the head.
10 stitches in the head.
I read that, Judge.
Tell me about the second one. What happened with the second one?
The second one is this one, and then you want
All
to
right,
tell
all right. How
us.
are we talking injuries on the second?
Judge, it's swelling and then bruising in the head.
All right, so I'm going to do 10,002 on the first one, 5,000. So 10,003 on the first assault, 5,003 on the terroristic threat, and then I'll leave the second one as is, the new one as is. No, then that has, no, I need a new one on. Do we need to file a new one?
For the original.
Okay, can you, Sebastian, file a new order for protection on the old case so we can have him sign it?
Yes, do you want it
123.
on the two victims or just on the?
No, on both. On both. Yeah. All right. Good morning, Mr. Moore. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 31st, 2024, the officer initiated a traffic stop for the defendant's vehicle speeding 61 miles per hour in a 50-mile-per-hour zone at the 6100 block of South Highway 225. The officer made contact with the defendant, driver of the vehicle, and the officer observed an odor of marijuana. The defendant stated someone else possibly smoked marijuana inside the vehicle, and a PC search was conducted. The officer located 3 individual packages with a green leafy substance known to be marijuana based on training experience. The officer located these packages inside a red backpack on the back seat of the vehicle, and the marijuana was weighed, and the weight was 2.87 ounces.
Did you say, you said speeding? Did you?
61 and a 50.
Got it. Okay.
And the issue that I have with the PC, so in regards to the speeding allegation, there were 2 cars in front of my client prior to him being stopped. It was 3 a.m. in Pasadena. He had the nicer car and was pulled over. And also my client explained to officer when he asked him about the smell in the vehicle, he did tell him that he had CBD in the car. He said that I had 3 packs. I just purchased it. They're in my backpack in a bag. They were unopened at the time. The officer did take the bag so that he wasn't, he didn't know how CBD looked or smelled. So he was just gonna find it to be marijuana and would take him in for that, even though my client did prove up the fact that it was CBD in regards.
But if it's CBD and it's unopened, it wouldn't smell, right? Because it's vacuum sealed.
Well, no, it said it smelled something in the car, but the substance that he found in the packages, they were unopened, and those were CBD. That's what he said that he found to be marijuana. But my client let him know that this is CBD. It's in my backpack. When you search, you're gonna find it. It's gonna be in there. But I purchased it earlier today from a smoke shop, and so when the officer did retrieve them out of the backpack and asked about it, he's like, "Well, I can't tell the difference between, what CBD and marijuana is. I only know marijuana, so I'm gonna have to take you in on that."
What form is this CBD in?
It was like in a little,
Is it?
it was a flower. So
It is a flower.
So I know that the CBD flower and cannabis flower, they look very similar. So
Your Honor, if I may. So as the DIMS established, so the odor was enough from the search, and finding that leafy substance is enough because upon further testing, it may or may not, but just for the purpose of probable.
So I think for probable cause purposes, I think it's enough because the odor, right? Now, they're going to test it. If it tests different, then there we may have an issue. But as far as probable cause, and your record speaks for itself, Mr. Moore. Anytime you get pulled over, what's going to happen? You know what I mean? This is what? 1, 2, 3, 4, 5, 6 in my case. Anytime you get pulled over with your record, what's going to happen? Every single time. So why give him a reason? Really, we keep coming back. Can you run his license if he has?
Eligible, Your Honor.
All right, I'm not going to put any conditions. Just be careful. Don't pick up any new cases because I'm going to lose it at that point. You've got a great lawyer. Listen to her. She'll take care of you. If she tells me she can't get a hold of you, I'm going to revoke your bond. Just be good. Don't pick up any new cases. If you're going to drive, make sure you have insurance, car insurance. All right? Okay, guys.
thank you.
Yes, ma'am.